For many decades, the death penalty has been a heated topic in this country, and both sides are very passionate about their beliefs. This is not just a moral issue, it's also a legal one as well. The question of whether the death penalty is constitutional hinges on only 6 words in the US Constitution. The 8th Amendment states that the government cannot impose or inflict any cruel and unusual punishments on people. The Due Process Clause of the 14th Amendment incorporates this protection to the states as well. As a lawyer, I wanted to break down this issue and give you the current state of the law, as well as the arguments presented by both sides. After hearing the phrase cruel and unusual punishments, you probably have many questions, but 2 likely stand out. The first is, what standard applies to determine whether something is or is not cruel and unusual? The US Supreme Court has already held in Adkins v. Virginia that whether a punishment is cruel and unusual is judged not by the standards that prevailed in 1685, or when the Bill of Rights was adopted, but rather by those that currently prevail. This means that this standard will be interpreted from the evolving standards of decency that mark the progress of a maturing society. In other words, the 8th Amendment's protections of dignity reflects the nation we have been, the nation we are, and the nation that we aspire to be. While the standard may seem subjective, the court has clarified that while contemporary values are relevant, they are not conclusive to what is and is not cruel and unusual punishments. Those in favor of the death penalty say that executing murderers does not violate the standard because we should not aspire to be a nation that does not punish with equal force. Those opposed to the death penalty say that we have matured as a society, so this type of punishment is no longer needed and should be abolished. They also argue that the risk of condemning an innocent person is too great to justify it. The second question you might have is what types of punishments violate this standard? The Supreme Court has held that cruel and unusual punishments are those that are inherently barbaric, which are something more than the mere extinguishment of life. The court's rationale is that the 8th Amendment protects all people, even those who have committed serious crimes. Because of this, the Supreme Court has said that all forms of torture violate the 8th Amendment. This would include the use of the rack, which looks like this. It also means that burning at the stake and disemboweling are illegal. One last example of a cruel and unusual punishment would be something like crucifixion. Other than this limited list, the Supreme Court has never held a method of execution to be unconstitutional, although some state courts have. As you'll soon see, the case law on the death penalty has mainly revolved around the person being executed and the circumstances surrounding it. The Supreme Court has virtually limited the death penalty to the crime of murder. This means that an execution for any crime other than murder will amount to a cruel and unusual punishment. As a result of this limited scope, the Supreme Court also forbids any capital punishment for sex crimes. In Kennedy v. Louisiana, the Supreme Court explained its rationale and stated that while this offense is deserving of serious punishment, it does not compare with murder. As a result, it would be an excessive penalty under the 8th Amendment. Notably, the court has held that this rule applies even when the victim is a child. As you can see, the Supreme Court has drawn a firm line on what crimes warrant death and those that do not. The Supreme Court has also held that certain minors cannot be sentenced to death even if they commit murder. This means that minors under the age of 16 cannot be executed no matter how heinous the crime that they commit. The court listed several reasons for this rule. The first is that children have a lack of maturity and an underdeveloped sense of responsibility. Second, they are more vulnerable or susceptible to negative influences and outside pressures, such as peer pressure. Third, their character is not as well formed as that of an adult. The court has said that the rationale for this rule is to hopefully allow the minor to become rehabilitated. The final category of people who cannot be executed are those with mental disabilities. Like children, people with severe mental disabilities have a diminished personal responsibility for their crimes. Thus, the death penalty for these people violate the 8th Amendment. In the early history of the nation, hanging was nearly the universal form of execution. This trend continued through the Wild West to the early 1900s. However, the nation's opinion on public hangings dramatically shifted with the execution of Rainey Bethia in 1936. This spectacle was witnessed by more than 20,000 people, and newspapers picked up the story as well. While public executions continued until 1938, the widespread media attention and public outcry surrounding Bethia's execution led to a shift towards private executions. These private executions continued into 1996 when Billy Bailey was the last person to be hanged in the country. While not as widespread as hanging, firing squad was an approved method of capital punishment in the country. In 1879, the Supreme Court ruled in Wilkerson v. Utah that death by firing squad was legal and did not violate the 8th Amendment. In the late 19th century, the electric chair was adopted as an alternative to hanging. States began to make this change because they believed that electrocution was less painful and more humane than hanging. In 1888, New York became the first state in the country to adopt the electric chair, and William Kemmler was the first person to be executed by it. In an attempt to avoid his fate, Mr. Kemmler filed an appeal to the U.S. Supreme Court, claiming that the electric chair was a cruel and unusual punishment. The Supreme Court disagreed and held that the electric chair was not cruel because it was a more humane method than those that were available. Because of this ruling, Mr. Kemmler was executed, and the process took 8 minutes and 2 attempts. A New York Times reporter who was present described it as far worse than hanging and criticized the method as a disgrace to civilization. Capital punishment continued into 1972 when the U.S. Supreme Court in Furman v. Georgia temporarily paused all executions in the country for 4 years. Many people, even legal professionals, claim that Furman v. Georgia abolished the death penalty. However, that is not what the court held. The court specifically held that imposing the death penalty in this specific case was unconstitutional for the reasons that they outlined. One of the dissenting opinions in this case makes this fact crystal clear. A dissent is a minority opinion of the judges who disagreed with the majority opinion. The dissent even notes that only 2 of the 9 justices were in favor of a complete ban of the death penalty. The 4 dissenting justices wrote, "At the outset, it is important to note that only 2 members of the court, Mr. Justice Brennan and Mr. Justice Marshall, have concluded that the 8th Amendment prohibits capital punishment for all crimes and under all circumstances." The court did not rule that the death penalty was unconstitutional. It ruled that the way that it was being imposed was unconstitutional in this case. Specifically, the court noted that there was no consistent standard for when the death penalty was and was not being applied. This arbitrary application led to racial and economic bias, especially against poor and minority defendants. Because of this, the court essentially placed a pause on all executions in the country for 4 years to give the states time to make their laws consistent. After the Furman decision, Georgia, Florida, Texas, North Carolina, and Louisiana amended their death penalty laws. Those sentenced to death appealed to the U.S. Supreme Court to ask it to once and for all rule that capital punishment was cruel and unusual punishment. The court refused to do so and expressly held that we now hold that the punishment of death does not violate the Constitution. The court has consistently upheld this position to this day and has said that this question is settled. Once the Supreme Court gave the green light on executions, states began to look for new methods. A series of botched executions in the 1980s led to a rise in public disapproval of electrocution. To combat this disapproval, states moved to lethal injection, thinking it would be more humane. However, it appears that this is not the case. It has been reported that lethal injection is the most botched of the execution methods and estimated to go wrong more frequently than any other method. Until the late 2000s, most states used a 3-drug combination for lethal injections. However, by 2016, Pfizer and over 20 American and European pharmaceutical companies had blocked the sale of their drugs for use in lethal injections. Due to drug shortages, states began to experiment with 1 and 2 drug combinations, which were largely unsuccessful. Because of these issues, states began to once again explore alternative methods to executions. 5 states has legalized firing squad as an execution method. Those states are South Carolina, Mississippi, Utah, Oklahoma, and Idaho. In recent months, 2 individuals have been executed by firing squad. On March 7, 2025, Brad Sigmund was executed by South Carolina for 2 murders that he had committed. It was the first of its kind since 2010, when Rodney Gardner was executed for murder. The second was Mikhail Mahdi, who was executed on April 11th of 2025 for the murder of a police officer. While some view this method as regressive and barbaric, many people disagree, and even justices on the Supreme Court appear to support it. In her dissent in Arthur v. Dunn, Justice Sotomayor noted that firing squad would cause nearly instant death and be comparatively painless, and result in significantly fewer botched executions. Justice Sotomayor was joined by Justice Breyer, who retired from the court in 2022. In a different case, Justice Sotomayor wrote another dissent where she said that firing squad was relatively painless and vastly preferable to the excruciatingly painful death caused by lethal injection. This dissent was joined by Justice Ginsburg, Justice Breyer, and Justice Kagan. While Justice Ginsburg passed away in 2020, Justice Kagan is still in the court. As more states continue to adopt this alternative, we can only wait and see how this issue resolves in the courts. Currently, 5 states allow nitrogen gas as a method of execution. Those states include Alabama, Louisiana, Mississippi, Oklahoma, and Arkansas. However, Alabama is the only state that has actually carried out an execution using this method at this time. In 2024, Alabama executed 3 convicted murderers by gas. The first was Kenneth Smith. The second was Alan Miller. The third was Kerry Grayson. On February 6, 2025, Alabama also executed Demetrius Frazier by gas. After these executions, 3 of the largest nitrogen gas manufacturers refused to supply their products. As we're likely seeing a repeat of what happened with lethal injection, it is unknown at this time how the states are going to respond to this shortage. If you've made it this far into the video, you're probably wondering if a person can request an alternative method of execution. The Supreme Court has held that this is possible if 2 requirements are met. First, the person must establish that the state's method of execution presents a substantial risk of serious harm, a severe pain that is over and above death itself. This means a person is not guaranteed a painless death. The rationale for this holding is that eliminating all risk of pain would effectively outlaw the death penalty altogether. Second, the person must identify an alternative method that is not only feasible, but readily implemented and significantly reduces the risk of harm involved. While the standard might be difficult for some to meet, a process does exist for inmates to request an alternative method of execution. More than half the states, as well as the federal government and U.S. military, allow capital punishment. It is important to note that 4 of those states have paused all executions until further notice. While more than half the country allows the death penalty, very few states have actually executed a significant number of people. The remaining states and the District of Columbia have banned the death penalty and have determined it to be unconstitutional. It is important to know that public opinion on this issue mirrors the divide among the states. Based on the most recent polling from October of 2024, 53% of Americans support the death penalty. Based on this information, only time will tell how the American public's opinion on this issue will change in the future. After watching this video, I hope you have a better understanding of the death penalty and feel confident discussing it. If you're interested in learning about more constitutional protections, please check out the linked video where I discuss all U.S. amendments to the Constitution. I really hope you enjoyed the video, and if you did, please give it a like, subscribe, and share it with someone that you believe could benefit from it. I would really appreciate it, and I hope to see you in the next video.